Good afternoon, everyone, and thank you very much for joining us. On behalf of the Japan Institute of International Affairs, welcome to today's lunchtime webinar, Understanding the Strait of Hormuz and International Law in 1 hour. This is the third instrument of our lunchtime webinar series, following earlier sessions on JIIA space activities and international law and on the continental shelf and maritime delimitation. Today we return to the matter of the Strait of Hormuz and international law. I'd like to introduce today's speaker, Professor James Kraska, the U.S. Naval War College and visiting professor of the Harvard Law School. And he is an expert of international law and maritime security. A commentator today is Dr. Excuse me, Dr. Seiya Eifuku. Yeah. Dr. Seiya, senior fellow at the National Institute of Defense Studies. And he's also specialized in international law and maritime security. Yes. And also a few practical notes before we begin. First, today's lunchtime webinar is being recorded, and the recording will be made available afterwards on the website of JIIA and our YouTube channel. And second, we will have a Q&A session today. And for those of you online, you may enter your question at any time and using Q&A function in Zoom. And also, 本日、参加者の方、登録されている方、結構日本人の方が多いそうなの
Those of
で、
you who are registered today, I think most of you are Japanese, so please use the chat function.
スライドの和訳を、
We have, for your reference, we have some translation.
And,
That's for your reference.
Okay. Without further ado, the Professor Kraska, you have the floor. Thank you very much.
Thank you very kindly, Shim-san, and thank you also, Coach San, and everyone at Japan Institute of International Affairs. It's very much of an honor to be able to talk with all of the persons associated with JIIA, which is a leader globally in foreign policy and development of thoughts on contemporary events and building stability and rule of law throughout the world. So I'll talk about understanding the Strait of Hormuz and international law, and we'll talk about the issues governing the law of the sea there, briefly mention the legal issues that arose during the armed conflict, and then about finally concluding with some thoughts about the peace deal that has been negotiated. These are my personal thoughts, and but I think that it will provide at least some clarity on the international law issues. So if I'm on the first slide. So with regard to, is this the map of the Strait of Hormuz? Sorry. Okay. So with regard to the Strait of Hormuz, you can see the geography that this is 21 nautical miles wide. And what this means is that in the contemporary law of the sea, that there are 12-mile territorial seas overlapping from Iran and Oman. And so 21 nautical miles wide means that this is a strait used for international navigation. The legal issues at play here are that there are two navigational regimes, two sets of rules that are contested. The first is innocent passage, and Iran claims that innocent passage would apply because this is ordinary territorial sea for Iran or Oman. And you can see that their territorial seas are divided by the faint red line in the middle, which is the equal distance between these two countries. The second regime or set of rules is transit passage. And transit passage is a specialized set of rules that was negotiated in the Law of the Sea Convention on condition that the territorial sea expand from 3 nautical miles, which was the traditional limit, to 12 nautical miles, which is the current accepted limit. So with the expansion of the territorial sea from 3 miles to 12 miles, this was based on the condition that even though the coastal states had a larger territorial sea, that they would recognize this right of transit passage. Now, the key is that there's a large difference between these two sets of rules. With innocent passage, it may only be made on the surface. So surface vessels are entitled only to innocent passage. With transit passage, however, submarines can go under the water and aircraft can overfly the strait. And so transit passage has more rules or more robust rules, or greater rules that benefit the international community. Moreover, fundamentally, innocent passage may be suspended temporarily by the coastal state, but transit passage cannot be suspended. And so this is the core legal argument between these two. You can see with Iran's position, Iran says that the United States and Iran are not a party to the Law of the Sea Convention, and therefore the U.S. and other states are not entitled to transit passage because transit passage is part of the Law of the Sea Convention. Iran also requires prior authorization for foreign warships and indeed now suggests that it can control all ships transiting through the strait. So Iran says that the United States is not entitled to transit passage and that it will govern the strait only with innocent passage. Remember, innocent passage requires that because it's within the territorial sea, that states must recognize and comply if Iran suspends innocent passage. Iran believes that it may suspend at any time. So Iran says that innocent passage applies, and the United States says that transit passage applies. The U.S. view is grounded in the UN Convention on the Law of the Sea, and even though the United States is not a party or a member of that agreement, it is reflected in customary international law, and therefore the U.S. position is that it is binding on all states. So within the Law of the Sea, innocent passage is in Part 2 of the Convention, but in Part 3 of the Convention, it says that transit passage applies in those areas of the territorial sea that connect one part of the high seas or exclusive economic zone to another part of the high seas or exclusive economic zone. So in this case, of course, we have the Persian or Arabian Gulf, and it is connected by the Strait of Hormuz into the Indian Ocean or the Arabian Sea. And so because this is an area that connects one part of the high seas or EEZ to another part of the high seas or EEZ, then the regime or the set of rules of transit passage actually apply. So let's go on then to state practice. What has occurred over the preceding decades, Iran and Oman have co-proposed or cooperated in the proposal for the traffic separation schemes that apply in the Strait of Hormuz. And so there are traffic separation schemes, and these are 2-mile wide corridors, one going east and one going west. One of them is in Oman's territorial sea, and the other is in Iran's territorial sea. And both Iran and Oman proposed these traffic separation schemes in 1968, and then they were revised in 1973. And this proposal was made at the International Maritime Organization, which is the UN specialized agency for maritime matters. Now, under the Safety of Life at Sea Convention that both Iran and Oman are parties to, the traffic separation schemes are required and are mandatory. That means that all states must observe those traffic separation schemes, including Iran and Oman. So this was the case during the
Go to the next slide. Please say steps up. So next, go to next slide.
Okay, okay. So if you could go to next slide, state practice transit passage. Okay, that's great. Thank you. So this has been the state practice for the prior decades, where during the Iran-Iraq War, also during the 1990-1991 Gulf War, and in the intervening decades, vessels of all nations have enjoyed this right of transit passage. Remember that transit passage may not be suspended, and it also provides that the coastal state, Iran or Oman, may not hamper passage. They may not impose security regulations, economic regulations such as a toll, or enforce their environmental laws inside the strait that are inconsistent with international rules reflected in Part 3 of the Law of the Sea Convention. Now, Iran says that it's not a party to the Law of the Sea Convention, and therefore it does not have to observe or respect these rules. But another principle of international law is that once a country signs a treaty, then that country has an obligation already not to undermine or defeat the object and purpose of the convention. So Iran has signed the Law of the Sea Convention, and even though it is not a party or member of that convention, it still has a duty or an obligation not to undermine or defeat the object and purpose of the treaty. Of course, the fundamental object or purpose of that convention is to maintain freedom of navigation and overflight throughout the oceans, and especially through straits used for international navigation. So fundamentally, it comes down to the bargain that was negotiated in the Law of the Sea Convention was that coastal states would be entitled to a 12-mile territorial sea on the condition that they permit this regime of rules of transit passage. So let's move on quickly to U.S. interdiction of Iran's shadow fleet oil tankers. So Iran has about some 1,400 oil tankers that have been used to evade sanctions throughout the previous decades. And the U.S. Interdiction of these vessels is based upon their stateless character. So in the UN Convention on the Law of the Sea, which reflects customary law, all flag states are entitled to exercise complete and exclusive jurisdiction over their ships. But there are some exceptions. For example, any state may assert jurisdiction over a ship if it has been overtaken by pirates, or if the ship is involved in slave trafficking. Another justification that allows any country, the naval forces or Coast Guard forces of any country, to assert jurisdiction over a foreign ship is if that vessel is stateless. And this has been the case with numerous shadow fleet ships, not just from Iran, but also vessels involved in breaking sanctions against North Korea or Russia. And so these vessels acquire stateless character because they lack a valid claim of registry. They fail to make a claim that can be verified by Coast Guard or naval forces. They have a claim such as a flag of convenience, maybe Guyana, for example, and Guyana is not able to verify that claim, or they claim two different registries, in which case, in all these conditions, these vessels may be assimilated or considered to be stateless. The United States has a very broad doctrine of stateless vessels, which it has used against these shadow fleets to board Iranian oil tankers and enforce U.S. sanctions against them. And because these ships are connected to a foreign terrorist organization, which is the Iran Revolutionary Guard Corps, the United States can seize these ships and then sell them on the open market, taking title to these vessels. And this broad authority by the United States has been upheld by the U.S. 11th Circuit. There's no nexus or connection required between the ship and the United States in order to seize that vessel. Now let's move on to the conflict that hopefully is going to be resolved through this ceasefire that will be signed tomorrow. So with regard to the conflict, the United States and Israel conducted a armed defensive action against Iran in self-defense. It's a self-defense theory authorized under Article 51 of the United Nations Charter. And this is because the U.S. and Israel have experienced literally hundreds of attacks, either by Iran or its proxy forces, forces that are under the effective control of Iran over the previous 20 years. And actually, there's been about 200 over the previous 2 years, 200 attacks. These include attacks by Hamas in Gaza, Hezbollah in Lebanon, and Houthi insurgent forces in Yemen, attacking not just U.S. and Israel, but also the neighboring countries in the Gulf and numerous other vessels of numerous other countries that are not involved in these conflicts. So based on this armed conflict, the United States has enforced 3 methods of warfare that are authorized in the law of naval warfare that are only reserved for periods of armed conflict. The first is that the United States has conducted visit and search of Iranian vessels to ensure that they're not carrying contraband. And actually, visit and search may be enforced against even neutral flagged vessels, neutral ships from countries that are not involved in the conflict. Those merchant vessels may be boarded to determine whether they are aiding Iran. And so numerous ships have been boarded by U.S. forces. They have also been boarded to enforce a blockade. A blockade is a lawful method of warfare. Once there is an initiation of armed conflict, a blockade may be imposed on the ports or coastlines, anchorages, and roadsteads, anywhere that vessels enter into Iran may be blockaded. And the United States has done so. Now, this blockade is in contrast to Iran's unlawful blockade of the Strait, because Iran is purporting to restrict the movement of neutral ships, particularly from Asia. These could be vessels from China, Japan, Korea, Australia, and Singapore and other countries. Those states are not party to the conflict, and so Iran may not legally restrict their movement or their trade with states in the Gulf, such as Kuwait or Saudi Arabia. The U.S. blockade is only against Iranian ports, and it is a lawful method of warfare. The United States also has conducted prize capture. This is a method of naval warfare in which enemy merchant ships may be seized and the legal title to them may transfer after a judicial process. So this is a similar operation that has been conducted in peacetime with the sanctions enforcement and the forfeiture proceedings of these merchant ships because they are supporting the foreign terrorist organization of the Iran Revolutionary Guard Corps. Now, hopefully we have reached the end of this conflict and we will be able to fashion a durable peace. And so for the last few minutes, I just want to frame what the peace agreement looks like so far. It is a ceasefire and a memorandum of understanding. It is not a final peace agreement, but rather think of it in terms of an interim agreement to continue to negotiate the fine details over the next 60 days. And at that point, hopefully, we will have a permanent agreement and we can have stability and normal operations in the Strait of Hormuz. So the terms require that Iran use its best efforts to ensure safe transit through the Strait of Hormuz, and that it would not impose a toll, and that Iran's governance of the strait is in accordance with international law. And this means, of course, that those traffic separation schemes that already exist are observed, and that the terms of transit passage, which may not be suspended, it may not be hampered by the coastal state, that those terms are also observed. Right now, traffic is restarting. As of tomorrow, traffic will restart in the Strait of Hormuz, and the goal is to achieve the pre-war level of traffic over the next 30 days. The reason it's not entirely immediate is because there are still mines and potentially other obstacles that are in the strait, and these have to be removed to ensure the safe transit of vessels, and in particular, oil tankers. The United States, for its part, has agreed to lift the blockade, and the blockade will be lifted proportionally to the number of vessels that Iran is allowing through the strait, so that both as Iran permits vessels that go through the strait in a peaceful and normal function, that the blockade will be lifted and Iran will be able to operate its ports and vessels will be able to enter into its ports. There's also a requirement that Iran and Oman engage in a dialogue with the Gulf states and other states to govern the Strait of Hormuz and recognize the right of transit passage. And this actually brings to mind two ideas or concepts that might be employed in the final agreement. The first is that I would suggest that the United States and Iran pursue a Hormuz Declaration. A Hormuz Declaration that defines the right of transit passage and that relates that right of transit passage to the definition in the UN Convention on the Law of the Sea, even though neither country are a party to the treaty. This would be analogous or similar to an agreement that the United States and the Soviet Union reached in 1989 called the Jackson Hole Agreement. And this agreement resolved the definition of innocent passage during the Cold War. And it connected that definition to Part 2 of the Law of the Sea Convention, when the Soviet Union and the United States disagreed on the definition of that definition. Likewise, today, Iran and the United States should sign a Hormuz declaration that outlines the rights of transit passage and the duty of the coastal state of Iran not to hamper or interfere with transit passage. That would be one helpful element of an eventual peace agreement. And then the other is already obliquely or already mentioned in a little bit of an ambiguous way in the MOU, Memorandum of Understanding itself, and that is that there should be some type of cooperation between Iran and Oman on the one hand and the Gulf states that rely on the Strait of Hormuz for their international trade, as well as, I would suggest, other countries that use the strait, states like Japan or China, the United States, that use the strait and enjoy the right of transit passage. So there is an analogy that we may borrow from. In 2005, Indonesia, Malaysia, and Singapore worked with about 25 other countries to develop what's called the cooperative mechanism for the Straits of Malacca and Singapore. And in this cooperative mechanism, Japan was very much a leader in this process, by the way. The countries along the strait and the states that use the strait joined together to develop a plan and funding for aids to navigation, communication protocols, safety protocols or rules, search and rescue, all of the governance that's required for the safe, secure, and efficient operation, environmentally sound operation of the strait is included in the cooperative mechanism for the Strait of Malacca, and this would be an ideal model to import for a permanent peace agreement. With that, I thank you very much for your interest in this issue, and also I have a QR code of this article, Legal Vortex in the Strait of Hormuz, which I've drawn upon for this presentation. Thank you very much.
Thank you very much, Professor Kraska, and for your impressive presentation. What? Okay. My apologies for some technical issues. Some of slides today were not displayed properly. Okay, but in any case, let's move the Dr. F's comment. And Dr. F, may I ask you for your comment? Okay.
はい。
First of all.
承知しました。防衛研究所のEifukuです。倉塚先生、非常に興味深いご説明
My name is Eifuku from the National Institute for Defense Studies. Thank you very much, Professor, for your highly insightful presentation. Professor has discussed the current situation concerning the Strait of Hormuz from three perspectives: the law of the sea, peacetime sanctions, and law of armed conflict. And I would like to offer several comments about the law of the sea, and secondly, I'd like to talk about the law of armed conflict, and also the ceasefire agreement between the US and Iran. And I'll touch upon legal considerations for the international community to ensure the safe navigation of the strait in the future. So what we have to note in terms of the international law. First, one major issue under the law of the sea arising from the present situation concerns the navigation regime applicable to those parts of Iran's territorial sea where Iran is not a party to the UNCLOS. Professor Kraska pointed out that the regime of the transit passage established under UNCLOS has also become firmly established as a rule of customary international law. However, specifically, as the practice historically recognized under customary international law of establishing territorial seas wider than the traditional 3 nautical mile limit in international straits become established as a rule of customary international law today, Considering the historical process through which the 12 nautical mile territorial sea was codified under UNCLOS and the state practice concerning territorial seas in international straits, it would be difficult to say that such a principle has become established. This is because opposition to a 12 nautical mile territorial sea was expressed not only by major maritime powers such as US and Soviet Union, but also by Japan too. The concern was that if coastal states bordering international straits were permitted to establish territorial seas extending up to 12 nautical miles, many international straits would become entirely enclosed within territorial seas. As a result, coastal states could potentially prevent a passage of foreign vessels that would disrupt international maritime transport. To address these concerns, UNCLOS established the right of transit passage in international straits composed of territorial seas, under which coastal states may not suspend passage. In other words, allowing coastal states bordering international straits to establish territorial seas exceeding 3 nautical miles and thereby encompass the strait within the territorial seas was accepted only together with the transit passage regime. Japan enacted its Territorial Sea Act in 1977 and expanded its territorial sea from 3 to 12 nautical miles. However, with respect to the 5 straits used for international navigation, Seiya Strait, Tsugaru Strait, Eastern Channel of Tsushima Strait, Western Channel of Tsushima, and Otsumi Strait, Japan retained the 3 nautical mile limit. And even after Japan retained the 3 nautical mile territorial sea limit in those 5 straits. One reason given by the Japanese government was that as a maritime nation, Japan wished to promote policies that preserve freedom of navigation through important straits. However, the underlying intent appears to have been to prevent emergence of a customary international law rule allowing coastal states to establish territorial seas exceeding 3 nautical miles in international straits, and thereby encompassing entire international straits within their territorial seas, separate from the transit passage regime.
So if so, theoretically, the international strait could be setting up 3 nautical miles, and then will be structured by the coastal countries, and it will be not admitted under the CIL. And if so, the Iran, which is not a party to the UN Convention on the Law of the Sea, should not be able to establish any territorial sea exceeding 3 nautical miles. So the Strait of the Hormuz, there's extending area for 3 nautical miles, and then Omani territorial waters between them is not going to be a territorial waters of Iran. So this should be an area where a free passage should be admitted. So considering the above, Iran's claim is that transit passage system is not a system under customary international law, and its practice of establishing territory waters in the Strait of Hormuz with a width of exceeding 3 nautical miles, which is theoretically inconsistent. And another point is about the U.S. naval blockade. So, evaluation and what I should bring up as a non-conflicting country. And Professor Kraska already explained that the belligerent countries is going to the ports and to be able to block the enemy's ports. The aim is to evade any import that could be helping out the enemy countries. And in order to have this put on ground, there should be 3 requirements. So it has to be the use of the use of power and to be announcing publicly that the closures will be happening. So with that rule, the U.S. has been working on this and announcing the closure. So on April, President Trump has been announcing that immediately all the vessels that is crossing the Strait of Hormuz is going to be stopped at once. And Iran has been publicly announcing that all the vessels coming into the strait will no longer be able to pass through the passage free of charge. And for the neutral vessels, it needed a time frame in order to respond. However, on the April 12th, the Central Army of the U.S. Started the next day, the April 13th, one day after the notification, started the closure of the strait and closed all the straits going through the Hormuz of Strait, and then execution was made. So, however, the U.S. has been revising over, making an amendment that they will not be stopping and not getting in the way of the vessels that try to go through. So the social network comments by the President Trump is not bounded by the international law. However, we understand that this is valid based on international law, but then traditionally through the diplomatic routes, they must be announced. However, this time the announcement has been coming through the website or the social networks. So from the third country's eyes, I cannot be confirming the fact that there was any dissatisfaction that this is not in a public or official announcement. However, no sound of that is heard. Therefore, I think this is official announcement. And the other part of my talk is when America is exercising the use of arms to the Iran, America is announcing that this is a very legal way that they have been acting. However, thinking about what has been happening is so belligerent. So the right to the neutral countries, is it possible that this blockade of the Hormuz Strait will be applying? And regarding that, in 1934, there was the Budapest resolution having an understanding for the international law. And when there was belligerent countries, and then there was a neutral countries will be able to negate down having some actions from the belligerent country. So what is happening this time? So the America to the third country, they are now asking the third country vessels to follow that. And however, there was no countries at all that is negating what the America country is doing. So they had been taking nullification measures to the third country vessels. However, there was no protest heard. And thinking of that, for the third country, when the belligerent country, even if they are using the use of arms, and this is going to be an evidence that the belligerent countries could be imposing some actions on the third nations. But this time, the specificities of this time is that Iran is also having a strong actions to the international world. Therefore, what is going to be happening is my concern. And the second point is regarding Iran. Regarding the Hormuz trade, many people focus so much on that Iran is illegal in closing down and blocking the waterways. But through February 28th to March 11th, the Persian Gulf and Arabian Gulf, Iran has been making an attack to the commerce ships. And within the Iran territorial waters, they are attacking the commercial vessels too. And commercial vessels are not to be a target. when they became a target, it is a specific vessel that has some service to the enemy side. And within, the Iran is also attacking something very much against the international law, which should be condemned deeply, because they are attacking a vessel that is out of their territorial waters too. However, international society and community is not condemning Iran so much. However, to my view, I think they should be condemned. And lastly, going forward, the ceasefire and the agreement, the international law should be focusing on several points going forward. So to start with, the Iran is now connecting this closure of the straits with the conflict of the American. However, the international law and the arms law is having a description that they cannot halt the transit passage. Therefore, when the conflict has been coming to an end, it is not so that the strait is open and everybody congratulate, because it has been a right from the first, and I lack time. Therefore, I would like to close my comment.
Thank you very much, Dr. Eifuku. We would like to move
先生、ありがとうございます。
to the session
では、ここからは質疑
For those of you online, please enter your questions in by using the function of Q&A in Zoom. And for those of you in person, please press the button of your microphone and go ahead with your question or comment. And the question, yeah, in English and or in Japanese is perfectly welcome. Is there any question? Okay. So we receive a question from online, and excuse me. This question is Professor Kraska. What is legal threshold or legal threshold of proportionality and necessity in international law? And Professor Kraska, can you share your insight?
Yes, thank you very much for the question. So there's necessity and proportionality are required in the use of force, but there's two different aspects of the use of force. There's jus ad bellum and jus in bello, and necessity and proportionality are required in each one, but they mean slightly different things. So jus ad bellum is the decision to go to war. The U.S. and Israel decision to go to war is a question of jus ad bellum, and it requires that their response in self-defense be necessary. That is, that they are facing imminent attacks, continuing attacks, and also proportional. And proportional here means that the response by Israel and the U.S. in self-defense must be no more than is required to induce Iran to stop attacking the U.S. and Israel and its neighbors. In other words, you cannot use force that's so great that it's more than required to get Iran to stop its aggression. Now, once you're in an armed conflict, then methods and means of war that are lawful apply, like we've talked about blockade. And these have certain requirements too. For example, blockade requires notification, as Eifuku Sensei had mentioned. And this was fulfilled through a notice to mariners by the United States to going out to all the vessels. The use of force during an armed conflict is also subject to necessity. Military necessity means that there must be some military advantage of using that particular force. In other words, you may not just randomly bomb, say, a national park in Iran because there's no military necessity to do so. Only military targets are lawful. And furthermore, when you're attacking those military targets, the military advantage to be gained must be proportional to the anticipated civilian loss that you anticipate. So it doesn't mean that civilians are all the time going to be spared in armed conflict. All it means is that you anticipate that your military advantage in doing so will outweigh any harm to civilians before you conduct the attack.
Professor Kraska, thank you very much for your great answer. And we receive the question. This would be for Dr. Eifuku. 英福先生に、交戦放棄に関する質問です。
So this is to Professor Eifuku.
と第三国の関係に
So the relations between the war started country and the third country. So from the US versus Iran,
封鎖を主張できるのでしょうか。
and they claim the blockade.
戦時国際法
So even if illegally the war was started,
の利益を享受するのでしょうか。
and they enjoy the belligerent's right.
もともとですね、もともとは
Yes, thank you very much.
戦争っていうものは
The international law
戦争が
related war
起こることを前提にして作られてきたもの
was on the premise that the wars
それが
are
事件
legal.
を生んだのは
So
第一次世界
this
大
brought
戦
a dispute because after the Second World War,
で
there's non-belligerent pact. So under the UN chapter, it was established that the ban of the use of force was established.
戦争の違法化によって
So because of the illegality of the war and the ban of the use of force, belligerent parties, one of them used the force, and another one was a victim. That was the structure.
国際法上されるときに
According to the international law,
武力紛争法というか戦時国際法の平等手続きっていうのを実施する必要があるのかと
we have
いう
to
ことが
apply
論点と
law
して出てきたわけですが
as in traditional cases. That is a dispute.
朝鮮放棄
At least
というのは戦争の惨禍を結局減災して平和に
We have to reduce the damage from the war. So
というのを
as much as possible, we have to reduce the damage from the war.
作られたものですからこの趣旨っていうのは
So that is the gist.
違法に武力の行使に訴えた国と
So those who
の間で
are belligerent
両方に
illegally
ということはやっぱり
and for victimized
基本
countries,
的にですね求められる
this applies to both
で
parties. The situation hasn't changed.
変更すべきであると考えられるのは中立
And what we have to change is the neutral nations. To neutral nations,
は被害国と加害国であれば法的に同じではないのでそこで
their position is not the same as the victims and the belligerent party. So, for example, boarding and blockade
第三国に対してですね取るっていうことを
to the third country,
取るということを
that means
武力の
to a neutral country,
ということが論点として出てきて
we can use force for that. And that is a dispute point. As a result, in conclusion, 1938 Budapest agreement said that you cannot do it. And your question is that under such a circumstance, what is the relationship between the US and Iran?
まあ議論があるところではありますが、イランとアメリカの関係っていうのは
Where there should be some disagreement, which country is victim or belligerent? Well, putting that aside, they are both belligerents. So there's no problem about applying belligerent laws and regulations. And blockade, as I mentioned before,
通所までも結局阻止するということがある
includes neutral vessels.
イランっていうのは
However, as was in your question, Iran is an enemy country of the US. So blockade against Iran, can they do it because they are both belligerents?
だけど理論的に
Belligerents.
敵国であれば伝統的な
Theoretically, there is no issue, but according to the traditional international law, for your enemies, without using blockade, for enemy vessels, enemy commercial vessels, you can capture them only because they are an enemy. So a blockade against Iran, according to the law, is not so meaningful. They can do it, but it's meaningless. According to the law related to war, if it's an enemy vessel, you can capture it. However, well, it's an Iranian vessel en route to Iran, and as a blockade, the US used their forts. It's not a violation of the international law. However, we don't have to argue this based on the blockade scheme. I'm sorry, this is too technical. Maybe you couldn't understand, but that's my theory. Thank you. Thank you very much, Dr. Eifuku.
And this is short question from online, and from the viewpoint of international maritime law, which state is responsible for the clearing the mine? And this question would be for both of you, or firstly, Professor Kraska, may I ask you the answer?
Thank you. Both in international law and under the terms of this interim MOU, Iran is responsible for removing the mines, and we'll see if other countries are also going to aid or support that effort.
Traditionally, there is a convention related to laying mines. This is a very old law. Well, this is the international customary law. According to this convention, basically, mines should be removed by the country which laid the mines. But depending on the situation, if the mines are laid in the enemy territory, rather than going into the enemy territory, you can just give the information about the positions, and that is more rational. So if mines are put in the enemy's territory, you can give information to the enemy country, and the enemy country can remove it. So Iran, this time, in this case, Iran should have the duty to demine. However, if that is in a dangerous area, and this area is an Oman's territory, so Iran should notify Oman so that they can demine, and that is part of the systems. But however, in reality, it's a question if Oman has the capability to demine. So the international community has to have a discussion so that third countries can dispatch some troops to demine or to do mine sweeping. But we have to be very careful. We have to notify Oman so that there is no violation of the territorial right of Oman if we have to do it. Yes, thank you.
Excellency, and Professor Kraska, thank you very much for your answer. And first question is that this question would be Professor Kraska, and that I want to know the difference between obligation under Vienna Convention and under customary international law and a treaty UNCLOS, especially what is meaning of ratification? You mentioned that obligation under Article 18 of Vienna Convention. What is the difference between the obligations?
Yeah, thank you for the question. So, yes, as I mentioned, that once a country signs a treaty, then it has an obligation under the Vienna Convention on the Law of Treaties, which itself reflects customary law, that it not undermine the agreement or that it does not act inconsistent with the, quote, object and purpose of the agreement. In the case of Iran signing the Law of the Sea Convention, what this means is that it may not take steps or efforts that weaken or undermine the agreement, even though it does not have to affirmatively implement the terms. So in the case of the Strait of Hormuz, for example, there are requirements for states to seek IMO traffic separation schemes. There already is a traffic separation scheme in the Strait of Hormuz, so Iran does not have to take any steps like implementing the regime, but it also cannot stand in the way of other states enjoying their rights. Furthermore, as the question suggests, this right is already a feature of customary international law. And customary international law, just like treaty law, is binding, is legally binding, and requires those affirmative duties. Also, furthermore, there's other convention, as I mentioned, such as Safety of Life at Sea Convention, that require Iran separately outside of the Law of the Sea Convention to implement those traffic separation schemes.
Thank you for the answer, Professor Kraska. And the fifth question is that it would be also for Professor Kraska. Customary international law apply this case. If that is the case, is it okay for us to think that the later part of Articles 26 of UNCLOS apply this case? Iran can request payment only for specific services?
Yeah, so customary international law applies because neither Iran nor the United States are party. And under customary law, as well as the terms of the convention, genuine services such as port entry requirements for offloading of garbage or sewage, for example, or pilot services that may be required, those are legitimate, but there is no precedent or no lawful authority to impose fees to transit through a particular waterway. If you think about that, Japan, for example, would not be entitled to charge vessels that go through Japanese straits. This is completely inconsistent with the Law of the Sea Convention or the customary international law of the sea.
Thank you very much, Professor Kraska. And next question is also for Professor Kraska. It is that I would appreciate if you could give us your view on imposing service charges on passing ships to the Strait of Hormuz under agreement between Iran and Oman, if they agreed.
Yeah, it's a similar question, and of course that would be unlawful for Iran or Oman to charge fees. The same as that it would be unlawful for, as I mentioned, Japan to charge fees to go through its straits, or the United States to charge fees to go through the Bering Strait, or U.S. and Russia, or the U.S. to charge fees to go through the Florida Straits or the Aleutian Islands of Alaska. There's no precedent for this, and it's entirely inconsistent with the Law of the Sea Convention and with customary law. And actually, the control of straits in this manner was rejected by the International Court of Justice in the Corfu Channel case in 1949 that limited the right of the coastal state to try to control traffic through the strait, and it also validated the right of all countries to use straits.
Thank you, Professor Kraska. And in the interest of time, it would be a final question today. And this question is for Dr. Eifuku. Eifuku さん、質問が来ております。
We have a question to Mr. Dr. Eifuku. So for this matter, the conflict between US and Iran happened, and regarding the illegal support of this, how should Japan view this? What is going to be the political impact to Japan? And going forward, how should Japan be engaged into the international law?
承知しました。日本としてどういう政策を取ってい
So
く
you mean a policy of Japan going forward?
日本政
And
府
regarding that,
タンクの研究者
I am one of the researcher of the Japanese government's think tank. Therefore, I may not comment to the details. So just generically speaking.
今回現代国際法のやっぱり
So in the modern international law, the foundation is to have a peaceful resolution and to ban and conform on the ban of the use of armed forces.
ならないようにです
So
ね
not to make up into a conflict, the related engaged
韓国
countries
の行使に訴えて物事を結
must be careful
訴
in
えて紛争解決するっていうこと
calling for the usage of the armed forces. That should be refrained from, and then it should be brought into the International Court of Justice in order to make an adjustment. So that is what Japan can do as a policy.
海保庁
Other thing is,
言うと
from the
先ほど最後に申し上げた通り
perspective
イランは
of
そもそも
Iran,
ホルムズ海峡の封鎖をアメリカ
Iran has been blocking the waterways by connecting this incident with the Americans' use of arms.
この国際海峡における
And this is an international waterway, and they have a transit passage rule. So the coastal countries, even they become a belligerent country, by not closing the strait, the rule should have an ideal that these waterways should not be blocked in order to be used by other nations. But this time it did not happen, and the causal relation is that Iran is asserting that they blocked the strait because US has been blocking the strait first. However, it is not theoretically all right. Therefore,
そもそも、まあ
what Iran did this time is
紛争平和的
they were not starting to make a resolution in a peaceful manner.
ところであるんですけど
Well, they should be evaluated to some extent. However, fundamentally,
ためにですね
in order to work through with their policy, they are trying to enforce through a third country, and according to the modern
海洋関連国際法に照らしてですね
international law, it will not be tolerated. So that should be explained to Iran, and along with the international community, we have to be strong and firm so that Iran will never go into that road again. And towards the US,
武力不行使原則っていうのは遵守してほしいということを訴えていく
we would like to appeal to the US that they should not be using the armed forces. But this is just a comment from one researcher. So this is not a view of the government of Japan. It's not going to be guaranteeing the opinion of the Japanese government. Thank you very much, Dr. Eifuku.
Brings us to the end of today's webinar. And Professor Kraska and Dr. Eifuku, thank you very much for clear and illuminating our. The situation of Strait of Hormuz remains fast-moving and severe, and we JIIA will continue to follow it closely. And today's recording will be made available afterwards. And please keep your eyes on our website and our YouTube channel. And finally, on behalf of Japan Institute of International Affairs, thank you very much for joining us today. And with this, I would like to conclude this session. Thank you very much.